How does a criminal defense attorney get charges dismissed? If this is a question that you have, then you're in luck because I'm going to answer that for you right now. My name is Jamahl Kersey. I'm a criminal defense and immigration attorney in San Diego, and I've handled everything from small-time petty theft up to DUI, all the way up to high-profile homicide, and all stops in between. And so today I'm going to be answering your question on how a defense attorney gets charges dismissed. So basically what it comes down to is demonstrating to the prosecutor that they are not going to be able to prove their case beyond a reasonable doubt. So prosecutors will file charges against a person going into it believing that they'll be able to prove their case beyond a reasonable doubt. So maybe in a complaint you'll see a person is charged with a battery, a robbery, a burglary, and grand theft, right? So the prosecutors reviewed the evidence given to them by the law enforcement agency, and upon reviewing that information, those are the charges they decide to file against the client. And so ultimately the defense attorney, in working with his or her client, reviews that information, reviews the discovery with their client. This might be witness statements, photographs, video, lab reports. If there was any violence, there might be hospital records or medical records, anything like that. But the defense attorney is forming the defense strategy with his client and trying to come up with a way to demonstrate to the prosecutor that they are not going to be able to prove their case beyond a reasonable doubt. So there are some misconceptions in terms of how defense attorneys get charges dismissed. It's not because the prosecutor likes the defense attorney. It's not because the defense attorney knows the judge. It's not any of these things. Ultimately, it comes down to the defense attorney being able to successfully communicate to the prosecutor that they are not going to be able to prove their case beyond a reasonable doubt. And so sometimes that comes in the way of being able to demonstrate that certain evidence that the prosecutor thinks he's going to be able to get in will not come in. So you've probably heard of motions to suppress evidence. Well, if there was evidence that was unlawfully obtained, in violation of the accused's Fourth Amendment rights, then what can be filed is a motion to suppress. And if the defense is successful in that motion and the main evidence gets thrown out and the prosecutor no longer has a case, then that's going to result in a dismissal. And so sometimes, that process is circumvented by the defense attorney being able to say, hey, you're not even going to be able to get this information into evidence if this case were to go to trial. And if the prosecutor is convinced or agrees with that, then that can result in a dismissal. Or there could be identification issues. The accused ended up getting charged with this particular crime, but there could be shaky identification issues, or there could be witness credibility issues. Maybe the witness had a motive to lie and made something up. But there's all kinds of different things that the defense attorney can come up with in order to demonstrate that the prosecutor is not going to be able to prove their case beyond a reasonable doubt. And so that's what it takes. At the end of the day, it's the defense attorney's investigation of the facts, so that's using either himself or even hiring an investigator to assist in digging up facts that are going to support the defense's theory of the case. Also doing the legal research to see if there are any solid legal arguments that the defense has in order to, again, show that at the end of the day, if this case is going in front of a jury, prosecutor, Mr. Prosecutor, Ms. Prosecutor, you're not going to be able to prove your case beyond a reasonable doubt for X, Y, and Z reasons, and that's why you should dismiss the case. And if it's convincing enough, then that will be the result. Well, I hope this was informative to you. If you're watching this video, it may be because you have been charged with a crime and you have questions. If that's the case, feel free to give us a call at 619-399-3662. I'd be happy to answer all of your questions and see if we might be able to work together. All right, enjoy the rest of your day. Thanks so much for watching. Till next time.